Today we are going to take a look at the relationship between tort law and contract law. In particular, we are going to look at the differences between contract law and tort law, and indeed there are a number of grounds which allow us to distinguish between the two. First, tort law concerns a public duty, whilst contract law concerns private rights. As we have seen, contract law is a private system of law that applies to parties who have actually chosen to enter into a contract together. In this regard, the duties that are imposed on the parties result not so much from any moral consideration, but simply because the parties agreed to act and received payment for same. To the contrary, tort law is welfare-based, and to this extent is a public system of law, insofar as it imposes duties not because the parties reached an agreement, but because the imposition of the duty is a necessary good and arises out of the general contract that every citizen has entered into with society. Tort law is said to protect in rem, whilst contract law protects in personam. Thus, the scope of application of tort law, when compared to contract law, is clearly far greater. The duty imposed by tort law is a society-based duty and does not result from any express agreement by a party, as is the case with contract law. This goes a long way towards explaining why parties often seek to exempt or remove liability in tort law, in particular negligence, from the scope of their contracts. And in the common law, under the freedom of principle contract, they are to varying degrees allowed to do this. The second difference between contract law and tort law concerns the notion of foreseeability. In tort law, foreseeability is a criteria for establishing a duty and not just one for assessing damages. As we have seen, one of the main areas of tort law is the law of negligence, pursuant to which every person owes every other person a duty of care as regards their actions. The extent of this duty is defined by reference to the reasonable man. In this regard, one is liable under the law of negligence for loss resulting from acts where such loss could have been reasonably anticipated or foreseen. Thus, in tort law, and unlike contract law, foreseeability is not just a means of assessing damages, i.e., one is liable for the damages that one can reasonably foresee, but it is also a means of establishing whether there is actual liability between the parties, i.e., one is only liable for foreseeable harm. As already noted, in contract law, foreseeability is only used as a means of assessing damages. This is because the scope of the relationship between the parties is already defined in the contract document. The third difference between contract law and tort law concerns the issue of compensation. The role of damages in tort law is different from that in contract law. In tort law, a person is compensated for the loss they actually suffered. In contract law, damages are limited to placing the person in the position they would have been in had the contract been performed. As already pointed out, this is because liability in contract law, unlike tort law, is not imposed in the context of a social duty. Thus, a party is only owed what they are due under the terms of the contract that they entered into. The final difference between contract law and tort law concerns the question of punitive damages. Punitive damages exist in tort law in the US and to a limited extent in the UK, where they are referred to as exemplary damages. Punitive damages do not exist in contract law because a party is not being punished for not performing the contract. Rather, the other party is being compensated for that party's non-performance. Once again, this results from the lack of the moral stance that exists in contract law. However, there has been some talk of introducing some limited form of punitive damages into contract law, in particular in cases of willful breach of contract. However, in the view of many commentators, this would be an error and one that would show a misunderstanding of the actual role of contract law. We hope you enjoyed this look at the relationship between tort law and contract law.